Now for our special coverage, Fox News at Night, the Kavanaugh hearings. Today, the Supreme Court nominee finally got to talk substance amidst numerous outbursts and intense scrutiny about what kind of justice he would really be.
I've watched his performance, I've watched his statements, and honestly, they've been totally brilliant.
President Trump praising his second Supreme Court nominee, Brett Kavanaugh, as the judge continues to run a gauntlet marked by protesters. And senators still jousting over document production.
I would ask the chairman if he might look at some of these that are marked committee confidential.
Let me answer that for you. If you're interested in it, you could have been asking ever since August the 25th, I believe.
Today's question centering on guns.
So I've been very interested in your thinking on assault weapons.
Abortion.
I mean, you just can't. Yeah. Hey, what are you doing for lunch? Let's overrule Roe v. Wade. It doesn't work that way, right?
And on his evolution regarding whether a sitting president should be subjected to criminal and civil investigations while in office. As a member of Ken Starr's team, he advocated for aggressively questioning then-President Bill Clinton and helped to write the Starr report outlining the grounds for Clinton's eventual impeachment. Years later, he authored a law review article questioning the wisdom of subjecting sitting presidents to invasive investigations, while noting Congress holds the ultimate remedy, impeachment.
What changed was September 11th. That's what changed. President Bush said this will not happen again. And he was of single-minded focus. Every morning for the next 7 years for President Bush was still September 12th, 2001.
And it's Kavanaugh's time in the Bush White House post 9/11 that sparked numerous questions about whether he was involved in crafting warrantless surveillance programs or enhanced interrogation policies and the legal memos used to justify them.
I was not read into that program, not involved in crafting that program, nor crafting the legal justifications for that program.
And on the same day the president praised him, Kavanaugh was pressed about whether he could truly be independent from the man who would be responsible for his lifetime Supreme Court appointment.
We're in uncharted territory here. It is unprecedented for a Supreme Court nominee to be named by a president who is an unindicted co-conspirator. I would like your commitment that you will recuse yourself.
Senator, I think to be consistent with the principle of independence of the judiciary, I should not and may not make a commitment about how I would handle a particular case.
Kavanaugh was repeatedly pushed on his philosophy regarding interpretation of statutes and the concept of legislating from the bench. He said, "It's not my role to update or modify statutes. That's up to lawmakers. But as a judge, I can write opinions that may give some guidance." All right, for more, tonight's Legal Eagles, the former Deputy Assistant Attorney General in the Bush Justice Department, John Yoo, former DOJ Counsel Jamil Jaffer, and Senior Fellow at the Center for American Progress, Ian Millhiser. Thank you all, gentlemen, for being with us tonight.
Good to be here.
All right, John, I want to start with you because you got name-checked in the hearing today. This is something from Senator Leahy.
Did you ever work with John Yoo on the constitutional implications of any warrantless surveillance program?
Well, I can't rule that. Right in the wake of September 11th, it was all hands on deck on all fronts.
John, did you expect to come up today in this hearing?
Well, I think Senator Leahy's just practicing for when Trump nominates me to the Supreme Court.
We'll be standing by.
If Trump wanted to drive Leahy crazy, that's one thing he could do. But I can answer the question for Judge Kavanaugh because he may not remember it as well as I did being there after 9/11. But I can say categorically that Judge Kavanaugh was not working on, was not in any meetings, and did not work on any memos related to what became known as the terrorist surveillance program. In fact, as I think he tried to mention there, he wasn't read into any of the programs. So I think Senator Leahy doesn't really understand how classified programs work. If you're not read into something as sensitive, and that was the most sensitive program in the government at the time, you're not told about it, you can't work on it. You might have thoughts about something and you might speculate on things, but and I worked on that program, he was not part of the team that worked on it. He was not allowed to know about it.
Yeah, and
so he should have just answered no.
Yeah, and your name came up as well with crafting legal policy or justification for enhanced interrogation. He said also that was something he wasn't read into and didn't have any power to control or craft any of the legal policy for that as well. We also, too, today heard from Senator Graham asking the judge about how he decides cases and whether he's ever had to do something he wasn't personally happy about. Here's what he asked.
Have you ever made a legal decision that personally was upsetting to you?
Well, I'm sure I have.
And Ian, he went on to talk about Justice Kennedy having to write this opinion that upheld the legality or constitutionality of flag burning, saying, as a judge, if you're really going to call balls and strikes, sometimes you're going to get to an end result that may not line up with you personally. That should be the whole point.
Yeah, I mean, every judge is going to have some case where the law is just so clear they have to decide things a certain way. The question is, what do you do when there's play in the law? And, you know, what we see in Judge Kavanaugh's record on abortion, on issues like net neutrality, on the First Amendment, on campaign finance, on issue after issue after issue, when there is play in the law, he takes the conservative path. But, you know, in some cases, there just isn't play. In some case, no matter what judge you have on the case, they're going to decide it one way.
Well, it's interesting because with respect to things like even Obamacare, I mean, he's made decisions that have made conservatives wary about where he may be. So he's upset folks on both sides of the aisle in any occasion, as many judges who are on the bench long enough are going to do. Jamil, I want to talk to you about Senator Blumenthal. Kind of a two-part question, so I'll ask you quickly on this first one. He continues to refer to the president as an unindicted co-conspirator. Is that legally, technically correct?
We have not seen anything in any documents from the Justice Department that indicates the president was an unindicted co-conspirator. Oftentimes you would see that in a pleading, and we have not seen that. So that's a theory that he has, but not a fact that we know at this point.
Well, to that point, he then asked the nominee, Senator Blumenthal did, about whether or not he can be independent from the president. Here's what he asked him. Okay, we don't have it, so I'll tell you about it. He said basically to him, listen, this president, he called him the unindicted co-conspirator. He said, will you right now make a commitment to me that you are not going to take part in any civil or criminal case that would come before you as a justice if you make it to the bench? He said repeatedly, I want you to commit to recusing yourself. And what Kavanaugh said was, I can't commit to you on any case that may come before me for or against in any other way. He said, that's what nominees do. I've studied them, and I'm going to stick by that precedent. Jamil?
Yeah, I mean, look, Judge Kavanaugh has come up with a new term called nominee precedent. It's a common thing that a lot of nominees have done before, going all the way back to Thurgood Marshall, and Ruth Bader Ginsburg laid it out very clearly. No predictions, no forecasts, no hints. Justice Kagan said the same thing, no thumbs up, no thumbs down. This is very common. You don't ask, nor should you ask a sitting judge or a nominee up for the bench to make any commitments, and they should not answer that if asked to do that. It's not appropriate, and the senator knows that.
Okay, he spent 12 years on the bench, the federal bench, as an appellate judge. And Ian, he said today, he wakes up every day not ever thinking, how can I rewrite the law today? He says what he thinks about is how can I apply it as it's written. Do you buy that?
I mean, again, there's some cases where there's play in the law. There's some cases where there isn't play in the law. The Constitution says that you can't have unreasonable searches and seizures. It doesn't define what makes something reasonable. It says that there are these things that are called the privileges or immunities of citizenship. Doesn't tell you what they are. Doesn't tell you what cruel and unusual punishment is. So, you know, there's so many ambiguous phrases in the law that when a judge tells me, oh, I'm just going to do what's written, I'm inclined not to trust them because often the words only get you but so far.
Well, and it's interesting because, you know, he teaches in various classes. He's taught at Harvard Law. Justice Kagan was dean then when she brought him on to teach at Harvard. And he's talked about that he tells his students there's not as much ambiguity as folks want to think there is. Don't look for ambiguity when there is clarity. John, a lot of folks today taking issue with some of those things he said, but a lot of folks, it seems like, positioning themselves for 2020 as well. Did you get that impression?
I think that's definitely what's going on because, look, Brett Kavanaugh, he has two senators to thank, Harry Reid and Chuck Schumer, because they got rid of the filibuster for judicial appointment votes. And so no matter what the Democrats are going to do in the hearings or questions asked, the Republicans have the votes on the floor. And so I think what you're seeing here, Democrats are not really trying to take down Kavanaugh. I don't think they have the votes for it. They're trying to use the hearings for some other purpose, whether appealing for their base or, as you're suggesting, some people are using it to establish a platform to run for president.
And just to remind folks, they took down, the Democrats took down that filibuster down to 51 for lower court nominees. It was Republicans who ultimately decided they would do it for the Supreme Court as well. And that got us Justice Gorsuch and possibly a Justice Kavanaugh. We'll watch again tomorrow. John, Ian, and Jamil, thank you very much. Good to see you.
Thank you.